Recently, I've received a number of emails from pro ses who want to appeal their case from the district court to the circuit appellate court. But did you know that in appealing these cases, it is not the judge's job to show they were right. Rather, it is the pro se or the individual who is filing the appeal. It is that person's obligation to show that the court made a mistake. And that's what we're going to talk about. Two mistakes that the party making the appeal can demonstrate. So let's get started.
There is one thing I always say: focus on the facts and the law. From the outset of the lawsuit, you're going to focus on the facts and the law in the complaint. And once you have watched this video, you're going to appreciate my advice. A mistake of law occurs when a judge misinterprets or incorrectly applies a law during a trial, or when adjudicating a motion, for example, a motion for summary judgment, and when the plaintiff or the appellant is harmed as a result. And to demonstrate mistake of law, we're going to look at Dexter Kemp versus the United States. The case was appealed to the United States Supreme Court, and the issue for the Supreme Court was whether Rule 60B1 authorizes relief based on a district court's error of law. So let's look at the facts, or some of the facts that were material in this case. Kemp was convicted on drug and gun charges, and as a result, sentenced to 35 years in prison. He subsequently attempted to get his case reopened through a motion pursuant to Federal Rules of Civil Procedure 60B. He argued that his case should be reconsidered because of a mistake concerning a timing issue that occurred during his rehearing. The district court rejected Kemp's argument, and the 11th Circuit affirmed. Obviously, the case went to the United States Supreme Court through the various appeals. And the Supreme Court held this, that the Federal Rules of Civil Procedure 60B1 allows a party to seek relief from a final judgment based on, among other things, a mistake. Justice Clarence Thomas himself wrote for the majority. He stated, "The question presented is whether the term mistake includes a judge's error of law. We conclude," Justice Thomas said, "based on the text, structure, and history of Rule 60B, that a judge's errors of law are indeed mistakes under Rule 60B1. You'd want to read this case. You'll find that even though the court made this ruling, the court also found that the filing by Kemp was not timely. So when does a mistake of fact occurs? It's when a judge makes a mistake regarding the factual aspects of a case, such as the events that occurred or the interpretation of evidence presented. And to demonstrate mistake of fact, we're going to look at United States versus James Bowling, and it is a 7th Circuit 2014 case. And the issue here was whether the court's decision not to hear the defendant's defense violated his constitutional rights. So let's look at the facts. Bowling was scheduled to enter a guilty plea on certain criminal charges sometime in the immediate future. On July 14th, 2012, while the charges were pending and Bowling had not made his plea, Bowling attempted to purchase a firearm. And I think you know where I'm going with this. On October 23rd, 2012, Bowling finally pleaded guilty in exchange for the dismissal of state charges against him. On June 4th, 2013, the government charged Bowling with making a false statement under 18 U.S.C. 922A6. Now, of course, they're accusing him of making this false statement when he went to purchase a firearm. And you know, when you do these kinds of purchases, particularly as a felon, questions are going to be asked of you, right? Certain questions, and certain questions were asked, and Bowling responded no. And there was another question that they asked Bowling about where he resided, and they found that to be false as well. Guilty. Bowling appealed and argued the court prevented him from asserting a mistake of fact defense. The appellate court held the trial court infringed upon Bowling's constitutional rights in preventing him from developing a mistake of fact defense. It wrote in part, a mistake of fact defense relieves a person of criminal liability where a reasonable mistake of certain facts means that the person, Bowling in this case, did not have the culpable mental state required for the commission of the offense. And to that end, the court wrote, Section 922A6 requires that the government establish that the defendant acted knowingly, meaning that Bowling knew that his statement was false. And of course, the case was overturned. Remember I said you would appreciate this video as it relates to the facts and the law? The facts and the law throughout the litigation should be before you. Remember, when you file your lawsuit, know your facts in the law that makes up the cause of action. Some of you have experience responding to a motion to dismiss. And I have said to you, mirror the defendant's motion to dismiss. You read the defendant's motion to dismiss line by line. And everything that is stated in the motion to dismiss that is contrary to your facts and the law, you make a note right there until you finish your full review of that motion to dismiss or motion for summary judgment. And then you write your response. Same thing with a judge's order. You read it line by line. You mirror it. And when you run across something that is contrary to the facts or the law or both, you note it right there. And right there where you are, you cite the facts and you cite the law that you're going to use to refute the court's order. This is not disrespecting the court, but you are simply responding, showing that the court simply made a mistake. Mirror the court's ruling. Guys, I hope this has been helpful to you. I'm Advocate Lucinda, and we will see you next time. Take care.